everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 46th lecture. We take questions from the previously asked questions and we try to give answers. And dear friends, whatever the answers that we are giving, even you can further investigate the matter and you can come out with the best landmark judgments. So whatever the best possible manner that we can provide, we are providing it. But this is not the final words. This is only the guiding light for you people to make further research, understand and write precisely with time managing everything. So it is our regular practice that we recite the preamble of the Constitution of India before we start with our topic. The reason is we strongly believe that our founding fathers have laid down certain duties on us. As a citizen, we have onerous duty to make the India a wealthy nation, a prosperous nation. Therefore, it is a duty of every individual to work for the upliftment of this country and countrymen. So, we always say that preamble our goal and preamble our soul. Therefore, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, this should not only be your prayer. Whenever we draft any petitions, whenever we make any arguments before the court of law, even be it trial court, be it high court, or even before the highest court, that is the Supreme Court, we can always relate our topic, relate our cases with the preamble. Because the entire Constitution, they have many provisions, but the soul is the preamble. The objectives is in the preamble. Therefore, you can easily correlate. If there is some justice, if a student wants to write an examination and she is deprived of getting a hall ticket and she belongs to a very poor family, you can say, your lordships, direct the respondents to issue hall ticket in light of social justice. That is how you relate the preamble. Fraternity, assuring the dignity of the individual. So likewise, each and every averments in your pleadings, you can always correlate the preamble. So now moving on to today's topic, dear friends. What is the topic for today? Lecture number 46. The topic is, what is the difference? What is the difference between review, recall, modification? In addition, we can say clarification of an order. Where this question have come from, where we have taken it? I will tell you the question number also and why it is repeatedly asked. It is 2021 in the AOR examination question paper year 2021 part 2, question number 6. It carried 10 marks. What was the question? Sorry, I repeat. June 2019, I'm sorry. June 2019, part 3, question 10K. It carried 2 marks, but it is very, very effective for our practice is concerned. So the question they have asked is, what is the difference between an application for review, application for recall, and application for modification of an order? Hope the question is clear, dear friends. So to understand this question, how are we going to approach? First, let us see what is review. Article 137 of the Constitution of India deals with review jurisdiction of the Supreme Court. See, what is the basic structure in the Supreme Court is, you file a special petition. If it is allowed, well and good, but somebody is aggrieved, the aggrieved party will file a review petition under Article 136, 137, read with Order 47 of Supreme Court rules. Once the review is also dismissed, then there is a scope for curative petition. That is one of the last resort in the Supreme Court of India. But whenever the stages increases from SLP to review, review to curative, the scope of entertaining those review and curative becomes limited. But it is not completely closed. The remedy is not closed, but you cannot urge your review petition as that of your original petition. Original proceedings are different. Review proceedings are different. Firstly, I will tell you why the scope is limited. Scope of interference by the court is limited. Scope is limited because there should be a finality attached to the any judgment or order pronounced. So therefore, we cannot adjudicate on the same issue repeatedly until we win the case. That is not possible. So that is why the scope is limited. But why the remedy is not fully closed? Why they have given a limited way to re-adjudicate? The answer is judicial fallibility. Because judges, the honorable judges have themselves said that though we are sitting in the institution as a Supreme Court judge, but we are also human beings. We are at times commit mistakes. Because of that, it should not lead to gross miscarriage of justice, travesty of justice. So to uphold justice, if there is any mistakes or any error that we have committed, please bring it to our notice. That is how curative petition was also born from the case Rupa Ashokura versus Ashokura case. Because there the honorable court held that if there is a element of bias, or if there is a gross violation of the principles of natural justice, they cannot be deprived of from getting justice. Therefore, curative petition. The constitutional law does not provide for it, but the Supreme Court rules provides by virtue of the judgment. So now coming to Article 137, dear friends, now we are going to explain what is review. So I have explained you about the principles. Firstly, finality to the judgment. Second is recognizing the judicial fallibility. So based on this, the scope is limited. Now what does it say, Article 137? It's a review jurisdiction vested with the Supreme Court. The Supreme Court shall review its own order or the judgments pronounced. Now we need to see Supreme Court rules also. Which Supreme Court rules deals with this review? Because substantial law comes from the Constitution, but procedure is Supreme Court rules. Under Article 145, clause 1, under article 145 clause 1 of the Supreme Court of the Constitution of India, empowers the Supreme Court to frame their own rules. So by virtue of that power, the Honorable Supreme Court, with the assent of the President of India, have framed the rules. So Order 47 of Supreme Court rules deals with review jurisdiction. So they are classifying two kinds of jurisdiction, dear friends. One is civil proceedings, another one is criminal proceedings. So when you are going to file a review in a civil proceedings, what are the grounds that we urge? Order 47 rule says that whatever the grounds provided under CPC, Order 47 of CPC, the same grounds can be urged even in the Supreme Court rules also. What about criminal proceedings? Error apparent on the face of the record. Now moving on to what Order 47 of CPC says. When there is a discovery of new documents, when it was not brought to the notice of the court when the order was passed with due diligence, some new discovery of new documents, or if the petitioner or the review petitioner is able to convince the court because of sufficient reason, the review has to be entertained. So these are the grounds provided under Order 47 of CPC. The same grounds can be urged in the SLP civil also, review in civil proceedings. Criminal proceedings, error apparent. You cannot fish out what is there, what is the mistake committed. You cannot search, but it should be apparent on the face of the record. By looking at it, anybody, any prudent man can understand that there is a error apparent on the face of the record. Only then the Honorable Supreme Court will interfere. So application for review when you file, what happens is it does not come in open court, and advocates do not get an opportunity to advance their arguments. So once you file a review petition, an application for review before the Supreme Court, matter is listed before it is circulated in the chambers. Once it is circulated in the chambers, we don't get an opportunity to present our case. But we can supplement along with the review petition the oral written arguments. So whatever you wanted to say, you can file a written argument. Two possibilities are there. One is dismissing in the chamber itself at the time of circulation. But when the Honorable Supreme Court wanted to interfere, they will issue a notice to the other side. Then matter comes up before the open court, where both the parties get an opportunity to advance their argument. Is it clear, dear friends? So review means you will not get an opportunity to address, because you must understand this. Very important. Now moving on to, say, recall, application for recall. In the application for recall, I just try to find out from the Supreme Court rules which rule provides for recall, which rule provides for modification, which rule provides for clarification. To the best of my knowledge, I could not find any specific rule in the Supreme Court Rules 2013. But what is there in practice? When you file IA or MA, miscellaneous application, for example, you file a MA for recall of an order, application for recall of a particular order. What does it mean? You want the Honorable Supreme Court to withdraw its previous order, to nullify the previous order, therefore recall the order. Under what circumstances it can be done? When the other party, one who files an application for recall, is in a position to establish that that order was obtained by playing fraud on the court, by misrepresentation of the facts, or misleading the court, suppression of material facts. Therefore, the Honorable Supreme Court misled, therefore the order was passed. Please recall the order. That is in the interest of justice, that application is moved. For example, in one of the cases, I will be dealing with it. An order was passed by the Honorable Supreme Court. Notice was issued to the other side. Thereafter, what happens? Informant, first informant, complainant, he was not a party to the proceedings, but he files an application. Two applications he files. One is an application for intervention, because you have to enter into the proceedings. You file either impediment or intervention, an application for intervention. Number two, an application for recall of the order dated which issued notice. Two applications. Intervention is allowed. Next is, why should we recall the order? That was the question posed by the Honorable Supreme Court, for which the intervener has submitted that SLP did not disclose the material facts. What was that material fact that was not disclosed before the court of law is, the appellant or the petitioner who has filed the SLP, he has not disclosed that he was sentenced to life. And more particularly, the Supreme Court had already held that concerned person remission cannot be entertained for at least 30 years. So these are the very crucial facts, dear friends, that a petitioner was convicted for 302. It went up to the Supreme Court. Supreme Court held that he was sentenced to life. There is a scope for remission. Therefore, the Honorable Supreme closes that remission. He cannot file for any remission until 30 years gets over. So these facts were not disclosed by the petitioner before the Supreme Court. So what was the impression created in the minds of the honorable judges was that it was a simple life sentence. Because of the suppression of the material fact, the impression created in the minds of the judges was that it was only a simple life sentence. So having suppressed these facts, when these facts brought to the notice of the Honorable Supreme Court, praying the Honorable Supreme Court to recall the order on the ground suppression of the material fact, misleading the court. So therefore, they have recalled their order which issued the notice. Is it clear, dear friends? Application for review is clear. Application for recall is also clear. Now, we need to deal with application for modification. What is that modification? The original order remains. It is not completely set aside or completely reversed. The original order remains, but it is modified to certain extent. Let me give you one example, therefore you can understand in a very better way. On 30th April, the matter came up before the Chief Justice Court, where I have appeared for the petitioner. I am not disclosing the name of the person. He was found guilty for illegally possessing narcotic drugs, ganja, weighing 8 kgs. Therefore, he was sentenced to life. Sorry, he was sentenced to 5 years. The maximum sentence is 10 years, but no prescribed minimum sentence. So the trial court has found him guilty and sentenced him to 5 years. Now he is aggrieved. He goes to the High Court. High Court also affirms the trial court judgment. So now concurrent findings. Both the trial court as well as the High Court have found him guilty and sentenced to 5 years. Now he approaches us to file special leave petition. Generally, dear friends, when concurrent findings are there, the Honorable Supreme Court do not interfere, generally. But when we bring out some question of law, or when we bring out certain perversity committed by the High Court, then the Honorable Supreme Court may interfere. In this case, we took up certain important issues, question of law, therefore notice was issued. And it came up for admission on 30th April before the Chief Justice Court. There, I have pointed out very important things, dear friends, because in the record in SLP, we have got enough materials we have produced. But which best point has to be focused? What should be conveyed to the judges? That is very, very important. When the judges sat around 2 o'clock after lunch, without going into the merits of the case, I have just circulated an office report to the judges. The office report reads like this. They have extracted the order of the court, previous order of the court, saying that the court directed the superintendent of prison to produce the conduct certificate of the convict, how he behaves with his inmates, how is his behavior for long 3 years. That was sought by the Honorable Supreme Court. Certificate was also filed by the superintendent of prison. It is already on record, but it is our duty to bring it to the notice of the court. That is how, I'm just deviating from here, it is pertinent to mention how effective the role of an advocate is. Former Judge Supreme Court, my Lord Vinith Saran, in his farewell function he had said, "Dear advocates, don't underestimate yourself. Don't be fearful at the time of advancing your arguments. You are like Lord Krishna. Advocates are like Lord Krishna and judges are like Arjun. We are the doers, but you are the one who is supposed to instruct us with a prayer, in a polite language, in a respectful language." So we made a humble submission. My lords, your own order, directing the superintendent of prison to submit a conduct certificate about the prisoner, who is the petitioner for whom I am representing. Please have a look at the conduct certificate. It reads like this. He is very good. He is a very good person, behaving very nicely with other inmates. He is working in a binding section and his behavior is fully satisfied and he has no other offences within the prison. So it is good and satisfactory. Once I read out that conduct certificate, entirely the mindset of the honorable judges got changed. And both of them have discussed and immediately they have asked the state to explain. And ultimately what they have done was, in NDPS case, here he carried 13 kgs of ganja. That was the allegation. It is neither a smaller quantity nor a commercial quantity. It falls in intermediate, and the punishment may extend up to 10 years, but no minimum punishment. Therefore, the Honorable Chief Justice have upheld the conviction. Conviction was not set aside. Conviction held by the trial court as well as by the High Court was confirmed by the Supreme Court, but modified the sentence. It was 5 years by the High Court. It was modified to 3 years and 2 months, which he has already undergone. And now he is released. That was the order. So modification is the original order remains, conviction remains, but modified to certain extent. Here modification from 5 years to 3 years. So this is how the modification, dear friends. And from this, what we have enough materials in the SLP paper book, but which is the best point? You must always discuss either with your friends or with your other colleagues to have a healthy debate, because we prepare in one way. When it is debated, when it is discussed in a healthy manner, we get different inputs and we can be prepared well. Therefore, in Parliament also there is a debate on certain issues. In the Supreme Court also, one side from the petitioner, another side from the respondent, then both the judges discuss. Reason is ultimately they need to uphold the justice, because aggrieved person is the common man. He doesn't know what is the ABC of law, though law presumes that everyone knows law. So it is our duty to provide justice to them. That is most important. Now, application for review, application for recall, application for modification is over. Though we have not asked for modification, but it was modified. Now, application for clarification. So the original order remains same, dear friends, but we wanted the Honorable Supreme Court to clarify to certain extent. So what is the relevant case law, dear friends? Please take note of this case. 2024, I repeat, 2024, Volume 2 Supreme Court cases, page number 334, 334. 2024, Volume 2 Supreme Court cases, page number 334. This is before a constitution bench, because the original judgment was made by the constitution bench. Therefore, any clarification also should come up before the same bench. This matter is Joseph Shine versus Union of India, where offense of adultery was struck down as unconstitutional because it was found to be held to be violative of Article 14, 15. Therefore, it was struck down. Now, what is the clarification? Clarification application moved by Union of India. Your Lordship have struck down 497. But as far as armed forces, army, navy, defense, it has a huge impact. And we have different acts. Navy Act is there, Army Act is there, where there are certain provisions in those special acts that discipline is to be maintained. If your Lordships have struck down 497, it has an impact on the officers, and how can we take action under those provisions? Therefore, please clarify that we have the liberty to take action against those officers under the special acts, and 497 will not bar the Union of India from taking action against those officers under the special act, because 497 was interpreted in the context of the marriage, not in the context of workplace. See how beautifully it is said, dear friends. Adultery is common. but it is viewed from the point of, in the context of the marriage, but not in the context of the workplace. So therefore, please clarify. So they have clarified in which, in this case, they have discussed about what is review, what is recall, modification, and why it is not being entertained. Generally, when you move an MA for clarification recall, the general notion of the Honorable Supreme Court is, here advocate is not filing a review because he will not get an opportunity of addressing the court. Therefore, in the guise of review, he has filed this. What you cannot do directly, he has done it indirectly to get audience in the court, open court. So that is how they take it when you file MA for clarification, recall, or modification. But once you satisfy them, this is what the reason, my lords, why I am seeking a recall or modification of the order. Clarification is being allowed. In this case, they have clarified. So genuine reasons will enable the Honorable Supreme Court to entertain. The general rule is they will not, but the exceptions is always there. In this case, the Honorable Supreme Court has clarified. Let me read that, dear friends. This court, in the case in question, was concerned only with the validity of section 497 of and section 198 subsection 2 of CRPC. This court spoke through separate but concurrent judgments, and the premise on which the provision was struck down was that it offended Article 14, 15 and 21 of the Constitution. In this view, the court had no occasion whatsoever to consider the effect of the provisions of the Act in question. In fact, we may notice that it is not as if this court approved of adultery. This court has found that adultery may be a moral wrong per Honorable Miss Justice Indu Malhotra. The court has also held that it will continue to be a ground for securing the dissolution of marriage. It has also been described as a civil wrong. In view of the fact, the scheme of the acts in the context, in particular in Article 33 of the Constitution, did not fall for consideration of this court, we must necessarily observe and clarify. Dear friends, this is important. We must necessarily observe and clarify that the judgment of this court in Joseph Shine versus Union of India was not at all concerned with the effect and operation of the relevant provisions in the acts like Navy Act, Army Act, which have been placed before us by the applicant, that is Union of India. In other words, this court was neither called upon nor has it ventured to pronounce on the effect of section 4563 of the 1950 Act, as also the corresponding provisions in other acts or any other provisions of this Act. We only make this position clear and dispose of the miscellaneous application, MA, miscellaneous application, pending application stand disposed of. So therefore, when there is a confusion with respect to the applicability of adultery, whether does it apply to those army officers, everything, so they have clarified that we have not said or we have not held that adultery is unconstitutional, we have declared, but whatever the provisions provided in the special acts, that action can be taken against them. To that extent, they have clarified, because army, defense, navy, discipline is very important. Otherwise, it will be considered as a grave offense. So they cannot dilute it. So that is most important, dear friends. So what we have seen now so far is review provided under this provision, Order 47 Supreme Court rules, read with Article 137. For recall, modification, clarification, everything, there is no specific provisions. To the best of my knowledge, I request, if you get it, please let us know. But that is being allowed. when we satisfy the honorable court that there is a judicial fallibility or there is a problem with respect to the understanding of the judgment, therefore please clarify or please recall because of that order obtained by fraud, or modify because it has to be modified to the extent in the interest of the justice. So otherwise what happens, dear friends, when we move MA after the disposal of the judgment, once SLP order is passed, once order is over, you wanted, instead of filing a review, you file MA by way of modification, by way of clarification or recall. Generally what happens is, this is general, there is order 15 of Supreme Court rules. It deals with petitions generally. I would like to draw your attention, this is very important, and this is one of the solutions even for to prevent docket explosion. So order 15 rule 5 of Supreme Court rules, the registrar, this is how it reads, dear friends, the registrar may refuse to receive a petition on the ground. For example, we have moved MA for recall or MA for modification, MA for clarification. If that is there, generally what the registrar does is, the registrar may refuse to receive a petition for clarification. Why? On the ground that it discloses no reasonable cause, or it is frivolous, or contains scandalous matter. So this is what, by which they can refuse. Generally, any clarification you file it, when you don't satisfy their conscience, it is rejected by the registrar. Then what is the remedy next? Remedy is, it's provided under order 15 rule 5 itself. But the petitioner may, within 15 days of the making of such order, appeal by way of motion from such refusal to the court. So you can appeal against the registrar order and it comes up before the court, open court. You have the right of, you will be arguing your case in the open court. You have to satisfy. If you don't satisfy, the honorable court even impose cost, because for wasting the judicial time. Because what you are supposed to file a review, but you have filed these applications, therefore we are not satisfied, they may impose cost also. Therefore, whenever you file, this is the provision, friends. Generally, it is dismissed by the registrar on the ground. It does not show any reasonable cause or frivolous or scandalous. The remedy is, within 15 days, you can approach the court by way of filing an appeal. Very rarely these provisions are used. So this is what, dear friends, thank you so much for your patience hearing. I am honored to present a topic on this.